Mr. Chairman, members of the board, I give you each a handout that you should have in your possession. And basically what that is a copy of an email that I sent to Ms. Nisivoccia yesterday. Basically, the email tells you about a story involving a Mrs. Salinas, who I met in court the other day. This lady is a Section 8 tenant that has, over the past 8 years, has paid her landlord over $20,000 for utilities that she was not supposed to be paying. She had an all-bills contract, meaning she pays no bills whatsoever, not one penny. Yet I have irrefutable evidence to show you that she, for the 8.5 years she's been there, has paid that landlord over $20,000. That's a heck of a lot more than the $500 that Mr. Nisivoccia used to terminate my 17 contracts in 2015. You do the math, but we've got the evidence. In fact, the Lighthouse is doing an investigation of that landlord now, but I'm going to take it further to probably the Office of the Inspector General, and probably the FBI, and probably the DA. $20,000, gentlemen, from the Section 8 family. Okay, so you can read that email. It's very pointed. It tells you everything. The next thing that I wanted to show you is pages 1 through 6 of the handout that I gave you. It's from the State Commission on Judicial Conduct. Now, you as attorneys, Mr. Ponick and Mr. Atkinson, would be aware, or probably familiar with this commission. They investigate judges that commit serious errors when they render decisions in cases. My case is featured in this, and that's 15-0774 in Justice of the Peace, Precinct 4. Yolanda Oreste was admonished and was told to take 80 hours of classroom study because of the way she rendered a decision in my case involving a Section 18 by the name of Mary Cordona. Go to page 3 of that handout. It's case CJC number 150074 JP, and the first thing it says that on May 5th, 2015, Judge Oreste presided over a case that I had in her court involving me and a lady named Maria Cordona. She prevailed, but according to the commission, she made a serious blunder. Her decision was flawed. She was admonished. She was ordered to go to school for 80 hours of classroom study. And this Monday, she did it again. I'm going to have to go back to the commission because she ruled against the Section 8 tenant who was there. And she went ahead and rendered an erroneous decision. We're going to challenge it. We've appealed the decision. But this is just proof that a JP judge doesn't necessarily render orders or decisions according to law. And this is a perfect case where this judge in Precinct 4 consistently and repeatedly does stuff that's not right. I wanted you to look at that because, to my knowledge, Ms. Mary Cordona is still in the Section 8 program. She should have been thrown out like other people have, but yet you protected her, Mr. Nisivoccia, by giving her a voucher, even though the commission says she did a poor job of rendering a decision in that case. I will tell you also that all I learned today was very disturbing, Mr. Chairman. I just had a conversation with Ms. Clara Gomez, who left, Gary Baxter, and Pedro Ortega regarding Mrs. Gomez's attempts to get a house owned by ELM Home Builders Incorporated. My wife and my sister sold their properties under duress because they were at the point of filing for bankruptcy because of what SAHA did in 2015 when you terminated 17 contracts. 2 of those 17 people are still living in the houses a year and a half later, making their co-payments, waiting for housing to make a decision that they can stay in place. I've never heard of a tenant going 18 months without paying rent, or SAHA not paying rent, and see if that's under the Code of Federal Regulations. You're going to find that that's a violation, Mr. Chairman. Now, the disturbing thing is that Ms. Gomez wants to rent from ELM Home Builders Incorporated, which, according to Mr. Lugg, is not shown as a registered or the recorded owner of the property. Well, Mr. Kenneth Grubbs is handling the 27 warranty deeds transferring ownership from Stella and Yolanda to ELM Home Builders Inc. Corporation. That takes time. It's not done instantaneously. So SAHA is being made aware that we have an attorney doing the warranty deeds. In the meantime, you can ask for legal advice from Mr. Ponick or Mr. Atkinson to see if an attorney doing the warranty deeds should have sufficient time to have those recorded. But the point is, the point of sale was done in January. The fact that it takes 2 or 3 months for the ownership to reflect on the records should not be taken into consideration to deny these people submitting an RTA. It's very egregious. The other thing is, I was told in front of Mrs. Gomez that she could port out. I've got here something called Housing Choice Voucher Portability Request. She's going to port out to the Housing Authority, Bexar County, tomorrow. So she can stay with ELM Home Builders, Inc., which you guys are denying to participate in the program because he still doesn't show as the owner of the properties. That's, in my opinion, wrong. But Pat and Gary told me, had I asked for a portability request for my 15 clients back in November of 2015, those 15 clients could have been ported over to the Housing Authority of Bexar County.
What kind of request?
It's called a Housing Choice Voucher Portability Request.
Portability, okay.
I could have had 15 of my tenants come in and fill these and be moved over there. They're doing it for these people now because they don't want to stay with SAHA because SAHA will not do business with the new owner. But 15 people could have put it over, Mr. Chairman. You moved 8 of Mayor Taylor's contracts over there. Had I known this, we would have done it. But you know what Gary and Pat told me? You didn't ask for it. Well, I'm asking it for it now. Any person that comes in and wants to be ported over, I hope you'll honor that request so they can stay with the new owner of the properties that at one time managed. Thank you.